The 14th Amendment is under attack from the left. They don't like equal protection under the law. They don't like it, and they want to end it. One of the other important cases we're pursuing, it's a historic case and it's a national case that a lot of people are focused on, is our class action civil rights lawsuit against the City of Evanston, Illinois. They have a program to provide cash based on race. There are two groups of people that are eligible. If they were residents of Evanston during a certain period of time, I think it was 1919 to 1969, or they had parents, grandparents, or great-grandparents who were residents of Evanston. And they're black. They don't have to prove discrimination. All you have to say is, I was a resident and I identify as black. Or my parent or grandparent, etc., was a resident and identify as black. And right now they're getting $25,000, or have gotten $25,000 if they fit that criteria. Our Judicial Watch's clients are white and would otherwise be eligible but for the color of their skin. So it's a discriminatory program based solely on race. And as you know, reparations is the new hobby horse for the left. They want to redistribute wealth and undermine America through reparation systems and reparation programs, divide our country. And much of what they promote in terms of reparations is just race discrimination or distribution of race, redistribution of wealth, using race as a pretext, all of which is unconstitutional and illegal, in my view, under federal law, and as we allege in this lawsuit. And so we sued, and Evanston, which is well represented, I think they got a big law firm working against us here. They're trying to throw the case out based on standing, that our clients don't have standing. So we're trying to keep the case alive. So they don't want to really address the merits of the claim. They just don't want anyone to be able to sue. At least they don't want our clients to be able to sue. And this is how we respond. Plaintiffs have alleged all facts necessary to state a timely claim that but for their race they are eligible to participate in the program and receive $25,000 direct cash payments. The program's eligibility requirements are simple, straightforward, and easy to satisfy, and plaintiffs have alleged they were and are, quote, ready and able to satisfy them at all relevant times. The program's use of a race-based eligibility requirement is presumptively unconstitutional, and remedying societal discrimination is not a compelling government interest. So you can only engage in discrimination if you've got a compelling government interest. I don't buy that, but nor is remedying discrimination from as many as 105 years ago or remedying intergenerational discrimination ever been recognized as a compelling government interest. Among the program's other fatal flaws is that it uses race as a proxy for discrimination without requiring proof of discrimination. Are there people who live in Evanston in that time period who were discriminated against? I'm sure. I'm sure. But that's not the qualification. You don't have to show you've been discriminated against. You don't have to show you've been harmed. They're just giving you $25,000 because of the color of your skin. And that's not right under our Constitution. Evanston's reparation scheme rejects a colorblind Constitution and unconstitutionally discriminates against anyone who does not identify as black or African American. The court should allow Judicial Watch's class action civil rights lawsuit to proceed. So we'll see what the court does. But as I noted, this case has gotten a lot of national attention because Evanston is the first official reparations program. And hopefully we can get the court to shut it down, vindicate our client's civil rights, and stop this venomous racialism before it gets out of the starting gate further. And, you know, this isn't the only area where we've been fighting the left's attempt to blow up our laws against race discrimination, which, by the way, are enshrined in the 14th Amendment. You know the phrase equal protection of the law? The left hates it because it gets in the way of their racialism. In Minneapolis, there was a public school, a union contract with public teachers, the Public Teachers Union. And if there were layoffs, as you know, under the contract, any layoffs, let's say the budget was cut and there would be layoffs, there would be, typically it's a matter of seniority. The people who are last hired are the first out. That's a typical public employee union contract, which I think is kind of outrageous in and of itself, because I think it should be who's the best worker. That's the way layoffs should be done. But that's not typically how it's done. It's usually seniority that provides you protection from layoffs in budgetary cuts. Or I shouldn't say usually, but it would be a standard contract. But in this case, there's an exception. It's first in, first out, unless you're black or a member of a quote an underrepresented group. You're skipped over and they go to the white person and they fire them or lay them off. How's that legal? It isn't. And that's why we sued. And the lower court initially, it's a taxpayer lawsuit because taxpayers have a right in Minnesota to challenge unlawful expenditures of taxpayer funds. In this case, expenditures that would promote discrimination and racism contrary to law. The Minnesota Court of Appeals reversed the lower court ruling that throughout the case, so the case was resurrected, but the teachers union appealed it to the Minnesota Supreme Court. So now we've got to go argue before the Minnesota Supreme Court why it is taxpayers can't be treating people based on race and firing or laying them off and hiring them back based on race. It's just incredible that there's even an issue here. But that's where the extremist left has gone. And that Minnesota Supreme Court argument takes place, I think it takes place on October 1st. So the week after next. We've had other cases, too, where in Asheville, North Carolina, they had a scholarship program funded by the city that was limited based on race. And as we sued, Asheville retracted the policy. In California, the left there passed 2 laws requiring gender, race, ethnicity, and other quotas for corporate boards of directors in private companies, public companies. Race, sex, ethnicity quotas, LGBT quotas, completely illegal under the California Constitution. And we won. We knocked them both out. There were 2 lawsuits we filed. We won both. Ended, thanks to Judicial Watch. So again, it's not just Judicial Watch complaining, it's Judicial Watch doing, as I like to say, the heavy lifting to advance the rule of law and to protect the Constitution, which is under attack. The 14th Amendment is under attack from the left. They don't like equal protection under the law. They don't like it, and they want to end it. And if that's ended, the republic ends, in my view.
Thanks for watching. Don't forget to hit that subscribe button and like our video down below.